Thank you to Professor Gunasekera and the team of academics within the university system who together produced what is, I see, as a very path-breaking document, an integrated, holistic approach to a problem that has long not been recognized in the university system, and for presenting it with this comprehensive focus, not only on just analysis, but on the strategies. This must be the first occasion in my life that I have been called Professor Emerita, and that is perhaps a measure of the engendered nature of this venture. I have to say, of course, that I was constantly referred to as a woman Vice-Chancellor, and therefore I took a cue from my peer who would constantly call me Sir. And I decided that I would prefer to be called Professor Gunasekera or Vice-Chancellor. I also want to say to the Chairman, UGC, Professor Mohan Silva, and the Vice-Chancellor, Dr. Gunasekera, and other members who are present here. What a pleasure it is to have with us people whom I think with an academic background who can give leadership to the university system and create a collegiate sense which is so crucial for the system. In the past several years, there have been many traffic lights and red light stops to our interaction and our conversation with this institution, and it is a measure of something special that today the UGC has taken ownership of this document and will, I hope, give leadership in that regard. That is certainly an important new beginning. I recall also a former professor of surgery who was also chairman of the UGC, Mr. Chairman, and I recall the many instances where the chairman of the UGC, Vice-Chancellor Gunasekera of the Open University, the president of FUTA, then Professor Sriyananda, all came together in this building to forge that system of payments and recognition of the necessary emoluments for staff in the Open University system. So that was a truly collegiate environment, and I hope that the UGC, as a regulator of the university system, will establish its connectivity with the collegiate sense. Because I see the UGC as very much, it's a regulator, but it's also integral to the university system. I insist therefore on the occasion to be present and to see your acknowledgement of the work that has been done, and also your interest or commitment to mainstreaming gender. Now, gender-based violence in the university system has, as has been pointed out by Professor Gunasekera and recognized by many, as a hidden issue in the university system. Why has it been a hidden issue? It's not that this violence has not been apparent, but there has been a lack of a commitment to recognizing it and addressing it. Now, if you look at the forms of gender-based violence in the university system, in my experience, it is hard to come across cases of murder in the university system, and I would be very interested to see the case that we think of is the Calumet University case, an appalling instance of gender-based violence. Because in the past, when we taught law, if a girl would not marry you or a boy would not marry a girl, you had what is called, or had there was a promise of marriage, and then the relationship didn't work out, what you had was an action for breach of promise of marriage. But in this instance in the University of California, you had this pathetic saga of relationship which had broken down, and the girl begging the boy to say, please, let us go on with our lives, finish our academic life, not together, but as two separate individuals. And he said no. And he came on a day, on ordinary day on campus, took a knife, stabbed her, and she died. And when the case went to court, the court decided that there was provocation in this instance. she provoked him to a situation where he was desperate. And so this was not a case of murder, but a case of what you call provocation, which reduces the crime to gangster. So we see the gender bias within the universities also reflected in the judicial system. So we have had, yes, cases of murder, but isolated. But what we have is grave and grievous hurt. Physical hurt caused to women, and also what we have seen is sexual violence in women. And one of the cases that we tend to ignore was that sometimes this violence was also perpetrated by women students against women students. And a classic instance was a girl who leapt off the top floor of the Vijayawardhana Hall and broke her back and has been crippled for the rest of her life. Unfortunately, she was not like a medical student who got the support to continue her education. She dropped out of the system. So from that time, and that was in the 60s, what we have seen is appalling levels of grievous hurt and sexual violence in the universities. And it was in recognition of that that we have put into place legal controls. And when I was on the UGC, Richard Patirana set up this committee, and I chaired it. And in 1998, we drew up the Ragging in Universities Act. That was a piece of legislation aimed at addressing gender-based violence and other forms of violence. And there are specific provisions in that act for sexual harassment and grievous hurt, which is gender-based violence. So what was the purpose of that? The purpose of that was to give recognition to this concept that women were suffering violence because they were women, which is gender-based violence, as Professor Michael pointed out. The background of the power relationships, the gender bias, the discrimination, manifesting itself in violence. Women were suffering it, especially, and recognizing that. Now that piece of legislation sought to endorse the approach of our Constitution, which has a provision on equality, equal rights, non-discrimination. It sought to endorse the provisions in the article on torture, which says inhuman, degrading treatment is violence, and which places upon any organ of state, which is covered in universities, the responsibility for inaction or inaction in preventing this violence. So it's not just perpetrating violence, but inaction in preventing this. That's a violation of a fundamental right. Then in 1995, when the Penal Code was reformed, there was an antiquated section on assault that was repealed and in place, section 345 of the Penal Code, that was replaced with a specific offense of sexual harassment. And that specifically says that in the case of employers, there's a responsibility to intervene and prevent this kind of violence. Then we have a Torture Act again, a piece of legislation which makes this a very serious offense, this kind of behavior. And of course, we have the labor laws, which also give the concept that sexual harassment in the workplace is unacceptable behavior because it creates an environment which can lead to hostile working conditions, hostile environment, which may require the person to leave. And when they leave, if they were going to labor tribunals, we have law, and there have been cases, the woman says, I was terminated, but actually I was terminated wrongly because this was constructive termination, because I had a hostile working environment at that point of work. So it is wrongful termination. And there are cases which are appear that. So we have the plethora of laws, the Constitution, the Labor Law, the Penal Code, the Torture Act, and the Ragging Act. All of this regulatory framework is there. Now in the recent past, we have been saying, laws are these spurious things, they don't really matter. We don't want regulation, we want economic growth, we